Alrighty, evening everyone. Thank you for coming. Some of you I recognise from last night, so thanks for coming for a second round of punishment, maybe, I don't know. So my name is Barry Allan, and I've been running these two, this session and the one last night on the End of Life Choice Act. And it's actually this one which was the inspiration for last night's one, because my friend and colleague here in the front row, Rex, he printed out the exposure draft and basically went, oh shit, that's huge, how's anyone going to understand that? He didn't use that word, he probably, and it made me sort of get a little bit of a sense of public duty come upon me, and thought, well, if he and I have trouble unpacking something like this, I hate to think what the humble voter out there in New Zealand, is how they're going to get to grips with what we're voting on. It is huge, so there's no way that we could possibly hope to unpack everything in this tonight. I'm going to hopefully pick out the core ideas of it, okay? And I just want to make a very preliminary introduction to my colleagues. So Professor Andrew Geddis is a professor in the law faculty, and he tends to teach public law as his speciality. I'm not an expert in drugs. My area is more consumer law and commercial law, but I'm interested in the kind of the market idea, because the whole idea of this exposure draft is to create a market. And it made me come into this and think, oh yes, I could talk about that. And then my other colleague, Dr. Duncan, is an employment and health and safety at work expert, and she's going to look largely from that perspective, okay? And I think my starting point, I've jumped ahead. So what I would say is that there are very few things in life are certain. I think taxes, death, and in New Zealand, cannabis, okay? Last night we talked about death, tonight it's cannabis, and I think what this exposure draft does for us is it exposes there's a stark choice between an outright ban, which is essentially what we have now, or trying in some way to regulate the market for cannabis and the use of cannabis. And so what Andrew is largely going to be doing is talking about how the current system is working and the kind of difficulties with it. He's then going to talk, because he's a public law person, he's interested in things like referenda, so he's going to talk about how the referendum came about and what it means to be an exposure draft. It's a fairly unusual procedure, and then the impact of the referendum that we're voting in on the 17th of October. So I'll hand over to Andrew. No need to clap. Hardly started. Oh, sorry. Technical hitch already.
So I wanted to sort of set the scene for the later discussion on what the proposed bill would do. And I want to do that by talking about what a current law is, the current statute that applies, and also the way that that current statute actually is applied in practice, and what it looks like on the ground. What I'm not going to talk about is what drugs do to people. None of us are medical folk. We can't really speak about the effects that cannabis have on people, the effects that cannabis have on young people, and so on and so on. It's just something we just don't know about. So we're going to be talking, about the stuff that we do know about, which is the law, legal regulation, etc. If that leaves big holes in our analysis, well, I apologise, but we can only talk on that which we know. So I want to start off by talking about what the current law is, because in order to assess any change to the law and what's proposed to change, we've got to do that against the background of, what is now. So the current law around cannabis sits within our Misuse of Drugs Act 1975. Interesting date, 1975. We've got the legislation on this is, 45 years old now. It's fairly old legislation. It hasn't undergone a huge amount of change in that time. We're still working off the framework that was put in place back in those days, that time. Under the Misuse of Drugs Act, cannabis is what is called a controlled drug. It's in a Class C drug. It's in Schedule 3 of the Misuse of Drugs Act. What that means in practice then, I should point out, I'm talking, when I talk about control of cannabis under the Misuse of Drugs Act, about what I'm going to call regular cannabis, which is the leaf that comes out of the plant. When you do things to cannabis, like turn it into cannabis oil or turn it into hashish or something like that, you change its status under the Misuse of Drugs Act. It becomes a Class B drug, and different forms of regulation apply. So I'm just going to talk about your regular old leaf cannabis that you get off the plant, dry, smoke, bake in a brownie, do whatever you want with. Regular cannabis, a Class C drug. That therefore means that under the Misuse of Drugs Act, it is a criminal offence to simply possess or use any amount of cannabis. So under Section 7.1 of the Misuse of Drugs Act, possessing or using any amount could send you to jail for 3 months or a $500 fine. A little asterisk beside that, because I'm going to come to some changes that have been put into the law to try to make sure that that doesn't happen to certain people when they're first entering into the criminal justice system. So I'll come back to that in a second. It's also an offence to possess any amount of cannabis to supply to others who are over 18. So if you have some cannabis and you give it to your friend and your friend is over 18, that's also an offence, which also is punishable by 3 months in jail or a $500 fine. It's then a more serious offence to possess any amount of cannabis to supply to people who are under 18. So if you have cannabis and you are going to give it to someone who's under 18, or if you possess cannabis with the intention to sell it on to other people, so you're going to give it to other people for money, that becomes a much more serious offence. Under Section 6.1, that can send you to jail for up to 7 years. So you're starting to get into some quite heavy-duty criminal liability at that point. There's then a kink in the tail of all of this, that if you are found in possession of more than 28 grams of cannabis, you are presumed to have that cannabis to sell to other people unless you can prove you're not going to do it. And of course that then puts you in line for the more serious possession for sale offence, could send you to jail for 7 years. So if you happen to have quite a large amount of cannabis on you, which you're planning to use for yourself, you need to be able to prove you are going to use it for yourself, because if you can't prove that, you run the risk of a reasonably serious jail sentence. That particular bit of the Misuse of Drugs Act has been found to be an unjustified limit on the right to be presumed innocent under the Bill of Rights Act. The Supreme Court found that, getting on for about 10 years ago now, and nothing's happened since. Parliament has continued to keep it in the law, so it continues to apply. Just to round it out, under the Misuse of Drugs Act, cannabis plants are prohibited plants. So if you are cultivating a cannabis plant, growing a cannabis plant in your shed or wherever else, that's a criminal offence in and of itself. Under Section 9, once again, up to 7 years of imprisonment. So the Misuse of Drugs Act sets up this very prohibitionary regime. It says, these are all offences, they're all criminal acts to which criminal tariffs apply, with the tariffs that are applying meant to sort of mark out the seriousness of each of the actions under the legislation. In order to try to mediate some of the effects of that prohibitionary regime, Parliament has moved to try to introduce some limits on the application of the criminal sanctions. So under Sections 7.5 and 7.6 of the Misuse of Drugs Act, last year Parliament introduced a measure to say that if someone is in possession of cannabis or has cannabis to supply to someone over 18, they don't have to be prosecuted, and in fact they should only be prosecuted if it's in the public interest to do so. And then, when considering whether it's in the public interest to prosecute someone for this, whether there's some sort of health response could be taken instead should be factored into that decision. So by passing this last year, what Parliament was trying to do was for people who just have cannabis on them, or maybe going to give cannabis to friends, rather than them going into the prosecution space, if there's a health response would be better instead, the police should use that instead. That was the intention with passing this sort of little kink in the prosecution aspect. And under section 7.2, there's an instruction given to judges that if you have someone who has been convicted of possession or supply to someone over 18, they shouldn't be sent to jail for that offence unless there's other aspects of their offending or other aspects of their past offending means you've got to send them to jail. So once again, that was Parliament trying to send a message to the judiciary that it doesn't really want to see people sent to jail simply for having drugs in their cannabis in their possession or having cannabis just to give to friends. So Parliament's already tried to take the overall prohibition approach in the Misuse of Drugs Act and soften it a little bit, at least in respect of this possession or possession to give to other friends type of aspect. That's the law. That's the Misuse of Drugs Act. That's the criminal sanctions as they apply to this particular substance. Alongside those criminal sanctions, there's then other aspects of the law that mean that that impact on people. Under the Search and Surveillance Act, which is the piece of legislation that tries to set out the ground rules under which the police and other enforcement officers can, search your stuff, under the Search and Surveillance Act, a police officer who suspects that you have cannabis on you can, without a warrant, search your property or vehicle, plus any people who happen to be on that property or in that vehicle. So a suspicion that you have drugs on you or in your car or on your property allows the police to, if they need to go on to search without a warrant, they can do so. Equally, suspicion of mere possession of cannabis allows for a warrantless search of a person. So if a police officer believes that you have cannabis on you in a public space, they can stop you and search you to find out if you do have it. Furthermore, just under general legal principles, reasonable suspicion that an offence against the Misuse of Drugs Act has been committed, that can be possession of cannabis, supplying cannabis to a friend, etc., is grounds for arrest. So even if no prosecution then follows, you can still enter into the criminal justice system because the police arrest you on suspicion of having carried out one of these offences, process you through the criminal justice system, and maybe at the end you don't get prosecuted, but you've still had that interaction with the police on that basis. So there's the offence provisions in the Misuse of Drugs Act, which can have quite heavy consequences for people if they're actually charged and convicted and sentenced. There's also, these other law enforcement powers that go alongside those offence provisions that can impact quite heavily upon people's lives. The police can search you to find if you've got drugs. The police can arrest you and put you into the whole system if they think you've got drugs, and so on. How this is then enforced, how this is then, put into practice is quite highly discretionary because it comes down primarily to an individual officer interacting with an individual or group of individuals and making decisions on whether to exercise their powers to search or to arrest under the Misuse of Drugs Act. And that then gives officers quite significant freedoms. And that's the way our law enforcement works, that, the officer on the ground has to make calls on how to interact with individuals and, when to, in effect, turn a blind eye, or when, in effect, to just give a warning and go on your way, or when to actually formally arrest and bring you into the system, and so on. And that exercise of discretion inevitably leads to quite differential outcomes. One of the differential outcomes that is just really, really important to recognise in New Zealand is that this discretion turns in practice on the ground into much greater enforcement action against Māori. And Richie Poulton and a whole bunch of other authors who run the Dunedin Multidisciplinary Study, which has tracked, people over years and years and years to see, how their lives have played out over time. As a result of all the data that they've collected, looking back over those years, they found that Māori rates of arrest and conviction are 3 times higher than non-Māori, even when you take other factors into account. So if you normalise out having a previous police record, etc., just being Māori makes you 3 times more likely to be arrested and convicted for a drugs offence than being non-Māori. Further, I think it's really important when we're discussing legalisation, the bill and so on, is to recognise that the social costs of engagement with the criminal justice system can be really high. So a lot of the discussion in this field is on the health risk and the health costs and the impact on the health of individuals of the use of cannabis. And that's really, really important. But it's really important also to recognise that engaging with the criminal justice system, especially being convicted of and punished for a Misuse of Drugs Act offence, really wrecks people's lives as well. So there's counteracting harms that need balanced out. How those harms can be balanced out, we can discuss and so on, but it is important to get this harm on the table. I mentioned that last year Parliament tried to mediate the prohibitionist approach in the Misuse of Drugs Act through the instruction or the recognition of police discretion and, trying to prompt a more health-first approach when you come to things like possession and supply to those over 18. It doesn't look like that change to the Misuse of Drugs Act has had that much of an impact on actual police procedure. Possibly that's because this is what the police already thought they were doing. The police already thought they were carrying out this sort of process before the law change. So the law change just may have formalised the practice that the police thought they were following. But we can sort of see the numbers. This was the law change last year where this discretion was built into the Misuse of Drugs Act. And the numbers are still fairly static in terms of the arrests per month going forward. All of this leads me to some rule of law questions about the existing law. Public lawyer, concerned about rule of law and stuff like that. One of my big concerns in this area is that we have a law that is broken by the majority of the population during their lifetime. We now know people from the 1970s onwards, the vast majority of them are going to use cannabis at some point, even if it's just once or twice. It's a law that then gets applied in quite a selective manner according to individual discretion of the officer on the ground. So the effect that this law has on individuals very much depends on who the individual is and who the enforcement officer they may run into is and what they choose to do. And it's a law that's having disproportionate impacts on disadvantaged groups. That all makes me personally ask whether it's a good use of law as a regulatory tool. Law can do some stuff well, other stuff it just doesn't do so well. The criminal law can do some stuff well, other stuff the criminal law just can't do very well. Is the criminal law working well in this space? And in particular, how certain do we have to be that if we were to change away from this current prohibitionary approach, things would get worse? Because things could get worse. It's entirely possible you could change this approach and things get worse. But how certain would we have to be that that would happen in order to keep the law that we've got in place at the moment, knowing all the problems that it's got? That seems to me to be quite an important thing to try to balance up, to be thinking about when deciding what to do here. Okay, so what are we going to do? That's all by way of background. It's setting the scene for where we're at the moment. Barry and Dawn are going to talk about where we might move to if this bill is adopted. I want to spend the last 5 minutes of my time just quickly talking about what the referendum change process actually involves. What is it we're going to be doing? What's the date of the election? 17th, there we go. 17th, what is it we're going to do when we actually vote? So there's a referendum. The idea for this referendum came out of the Labour-Green Party agreement post-election. So when the Labour and the Green Party were working out how they would work together to allow a government to operate, one of the things that the Green Party said was, we want a referendum on legalisation of cannabis. In part, the existence of a referendum, no doubt, reflects the influence of New Zealand First. There was no way New Zealand First was going to vote for legislation to legalise cannabis in and of itself. The most they would go for would be to allow the people to vote at a referendum. It also probably, I think, reflects some division within the Labour Party over the issue. I think the Labour Party itself, there will be some MPs like the idea, there's probably a lot of MPs don't like it. This is a nice way for them to paper over those problems. After announcing there was going to be a referendum, the government very frantically tried to work out what should a law look like in this space and put together the draft Cannabis Legislation and Control Bill, which then became public in April. So in April, that pile of paper that Barry was holding up before was put out to the public, and come the 17th, you'll be asked to vote on whether you support or oppose the draft legislation that the government has put forward. The outcome of that vote actually has no legal meaning. Compared to the end-of-life choice referendum, which some of you were here to hear about last night, the end-of-life choice referendum, if a majority of people vote yes, then the End-of-Life Choice Act will take effect in a year's time. If a majority of people vote no, then the End-of-Life Choice Act will not take effect. It's law sitting there, ready to go, depending on how the vote goes. This draft legislation is just draft legislation. At the moment, it's just words on a bit of paper. It's got no legal status, so a vote yes or no, in terms of the law, actually carries no weight. However, the fact that the New Zealand public will vote one way or the other carries quite significant political moral weight. It's going to tell the government something. And the fact that this referendum's been put together, and the fact that all this money's been spent on holding it, means that it's going to carry some sort of weight going forward. If the vote on the bill is no, well, I don't know what'll happen. I mean, I think I could predict the bill wouldn't get passed into law, but something else might happen. There might be other movements in the cannabis space. I have no idea what those would be. However, if the vote is yes, then the Labour and Green parties have committed themselves to passing the bill. They said, we will pass the bill into law if a majority of people vote yes on it. The National Party has said that if there's a yes vote, they will take the bill as far as a select committee in Parliament and then let the select committee look at it and make recommendations. And if the select committee says don't go any further, then the National Party won't go any further. So the National Party is only committed to going to select committee, the first stage of the legislative process. The ACT Party also is committed to that, though I should note that David Seymour personally says he thinks it ought to become law. I went looking for what New Zealand First thinks, and I mean no disrespect to New Zealand First, but I just could not find out. The policy link on the New Zealand First Party page leads to their agreement for supply and confidence at the last election. There are no new policies up there at all. And a Google search, I just could not find any statement about what New Zealand First will do, so they may have a policy, I just couldn't find it. One thing I will note is that while the Labour and Greens have committed to enacting the bill through Parliament, they're not legally required to do that, and also the content of the draft bill could change during that legislative process. So if people vote yes, and the bill is put into Parliament, even with a Green Labour majority, it is possible that aspects of the bill could be changed just as part of the normal lawmaking process. That's a risk. It could happen. And that's all I have to say for the moment. I'll hand over to my colleagues to talk actually about the bill itself, and then any questions I can deal with later. Thank you very much.
Right. I think one thing I would say about the exposure draft is, even if it is to proceed, I do hope that it does come under some level of scrutiny, because I've read it several times now, and every time I read it I find more jarring bits that it's just not well drafted yet. So at least it needs to be refined to some extent. So my starting point now is that the government is recognising that when it comes to cannabis, an elimination strategy is not going to be effective. So the next best strategy that they're putting forward is to regulate the supply and the use of cannabis and related products. And the general idea of this strategy, and I've read Andrew Little's cabinet paper on this, is to move consumption away from the illicit supply into an orthodox market for both consumer side and supplier side, so that the consumers can come along and they can purchase from a safe, regulated source, and the suppliers have to comply with quite a lot of regulations to get their product into the marketplace, okay? And one obvious goal that the government would have to have in passing this legislation would have to make it more tolerable to both users and suppliers than what is now. So they don't want to put too many obstacles in people getting registered to be suppliers, for example. So if they make a very high registration fee, your smaller suppliers will say, well, I'll still sell from the back corner or whatever, okay? So I think one of the policy goals has to be to bring as many people under the coverage of the legislation as they can. And I think it's just this week, Canada went through this process a while ago, and they've just announced that the legal supply of cannabis in Canada has just exceeded the illicit supply. So I'm going to start just by talking about what we can do as people on the user side of things. And first I'm going to start for those who are under 20 with a preface. Everything I'm saying is about recreational use. It is not about medicinal use. That is covered by an amendment to the misuse of drugs legislation that Andrew talked about. And the aim of the proposed legislation is to have a very strong dividing line between those who are under 20 and those who are over 20. So they've put in place this minimum age of possession of 20, and I've put the clause numbers there if anyone wants to go and have a look at it later on. But one really good thing, I think, is that you've heard what the criminal consequences are at the moment for someone who has it when they shouldn't. Under the proposal, it'll be either a very small fine, $200 maximum, or an infringement notice. The same sort of thing as if you get parking more than 2 hours on a 2-hour parking meter. And even more importantly, if the person upon whom this has been served engages what's a support service, and it's not well defined at this stage, but someone who's going to give them some sort of drug counselling, I expect, then the infringement notice can be waived and there'll be no record of anything ever happening to that person, okay? So it does keep them out of the criminal justice system, or at least a pathway to that. How well it's going to work if it comes into play, who knows, because there'll still be that discretion to take people to court, but it'll only be a small fine. So people, I think, will get fed up taking that path. In terms of sharing, no private supply to or sharing with anyone under 19 or under. No exposure of emissions to those under 20 by smoking or vaping. So that means into the household where the parents have got children. They'll have to go out into the car maybe to have it, but they won't be able to do it with the children or anyone under 20 around them, okay? And people under 20 are not allowed on retail or consumption premises, and I'll be talking about them shortly. And it just occurred to me while Andrew was talking about current imprisonment regime, one of the few private use imprisonment provisions is that when there is a sale to someone under 20, that will lead to someone being imprisoned. But generally speaking, the emphasis has come off sending people to jail, come off having big swinging fines, okay? So private use for adults, there are limits as you'd expect. Anyone can have 2 plants, but it becomes difficult if they are sharing a property. And by this, I would mean, an apartment in a block would be a single property. So the fact that, someone who's got 2 plants in one apartment won't stop other people in the same block having their plants as well. But within a property, so a flat might have, 6 adults living in it, like student flats here. There can only be 4 in that property, even though there's an individual right to have 2 each. They can't be visible or accessible to the public, so they either have to be inside or in the back garden, but not on the street front, obviously. One thing that's going to create some problems, I think, so that the person to qualify has to have a relevant interest in the property. Now, if the owner of the property, that's no problem. But if they're not the owner, then the landlord has to give them a relevant permission. And it doesn't say permission to grow cannabis. Permission to have a garden will do the job, okay? But it does mean that the landlord has got some power here to say to its tenants, no cannabis to be grown on the property. And 2 plants, there's a minor penalty if there are up to 9. Go above 10, there's an increased penalty, and here there's an imprisonment regime possible. In terms of dry cannabis, 14 grams is the magic number here, and I'd suggest it's a sort of compromise between competing interests. I don't know how much that makes, but my research tells me it can be anywhere between 20 or 40 cigarettes, depending upon which website you look at. I have a suspicion it's far more than people would normally be smoking in a particular day, okay? But there's a daily limit of 14 grams. My research has told me that it's perfectly enough to make a cake or brownies, okay? But the tension here is, we've got real concern with having someone who is oversupplied with cannabis, okay, and it's a real temptation to addicts. So we do want to have an upper limit. But there's also the other side, why we might need more than what 1 people use in a day, because it might be something they'll do when they do their regular shop every week or 2 weeks, or they might have access difficulties, okay? And in a way, what we're doing is we're sort of normalising it by saying, oh, well, you don't need to sort of binge smoke. You don't have to make sure you get your supply every day. There's going to be secure supply. It's not like toilet paper during the pandemic, okay? I think, yeah. So that's a per day purchase limit, similar for in the public place. And there's also a regime for sort of equivalencies. So for example, if you've got seeds, then 1 seed is treated as being 1 gram. They also include in a vehicle in a public place. So you're okay in your own vehicle, in your own property, but leave that property with this, then you can only have 14 grams in your vehicle. Okay, no consumption in a public place or in a vehicle in a public place. But there's no overall limit on how much you can stockpile in your house. And then, Andrew was talking about sharing. They specifically looked at, okay, let's make cannabis use, let's recognise it's a social experience. And so, yes, it is possible to gift it, it's possible to share it, or supply in a variety of ways at a private level, so long as it's with someone who's over 20, so long as it's no more than 20 grams of dried cannabis or its equivalent, and nothing is received in return. It cannot be for any sort of reward, because that would turn it into a commercial supply for which a license is needed. So it's in the commercial sector we have this big shift, the transition from illicit to regulated supply chains. So we need the suppliers to come on board and to accept the regulation regime. So here things are a bit more serious in terms of potential penalties. So we do see imprisonment as a feature. Okay, so no sales of cannabis or cannabis products are permitted without a license. So even 1 gram, there are sentencing regimes in place that 1 gram would probably not see anyone see jail time, but it's potentially there. There are to be no imports. And the theory behind this is that they want to have a sort of a closed market, even though, of course, as things are imported, we kind of know what's coming into the country anyway. But no imports except for seeds. No one can really explain why there's no exports, but the proposal is none of this is to be exported. When we can't bring students in from overseas, maybe exporting drugs would save the economy, but no, we're not going down that path. We're not allowed mail order or courier supply, so every transaction has to involve someone going to a physical premises to get the product from an authorised provider. There is going to be a cultivation cap, and this is sort of supported by the import ban, so that the idea here is that, at least in the regulated sector, there will always only be a certain amount of cannabis circulating through the marketplace. And this cap has yet to be set, because we have an organisation that's going to be formed to set that cap, and it will also allocate to the individual licensees how much cannabis they are allowed to produce. So it's a wee bit like a fishing quota. It's probably a bit more like the Canadian tobacco growing quotas that they've had in place for years and years. And one thing that they've done with this market is they've created a very, what I call a segmented supply chain. So they're taking each step in the supply of cannabis, right from the seed right through to the supply to the ultimate consumer. And they've made that we have to have particular licenses for each type of participant. I've got a list of them. I'm not going to go through each one of them, but you can see we start from the nursery, the growing from a seed into a seedling, through cultivation. And there's 2 types of cultivators. I'm not entirely sure what the rationale is for that yet, but it's sort of growing the plants up to the point that they're ready to process. Then there is a processing license where we're actually taking the plants and producing cannabis and cannabis products. There's a wholesaling and distribution licensing, and that breaks down into retail and consumption premises and nursery retail. And the idea of a nursery retail is that's where people are going to grow at home, that they can go along to, well, they won't be going to Nichols Garden Centre, but they'll be able to go somewhere and they'll be able to buy some plants and take them home and grow them for themselves. So the retail supplier, this is enabled by Clause 71, and what they'll be doing is they'll be selling cannabis products. So that's anything which is containing cannabis. It has to be packaged and labelled as such, and we are selling this to the public. Okay, so you can get a licence for that, just like an off-licence liquor store. Okay, can't contain roots or stems. Maybe they're more potent, I'm not sure. I'm not a scientist. Can sell cannabis accessories, and so these will include things that we might use for other things, like smoking tobacco. You need papers, okay? So you can get licensed to sell cannabis accessories, and cannabis plants can also be sold through a retail outlet. The situation when it comes to cannabis edibles is very confusing. I've spent quite a long time trying to unpack this. So certainly the legislation does enable, ultimately, the ability to produce cannabis edibles and to sell them, okay? There are restrictions. They have to be baked and ready to eat. So we're talking about, pre-packaged cannabis muffins with a bit of maybe raspberry in there just to add a bit of difference, okay? They are to not require refrigeration or heating, and I'm not sure what that is. Water activity level, minus 0.85. Now, I've looked this up, and I don't quite know how they measure this, but when I found a list of equivalent products, hard cheddar cheese has 0.85 water activity level. So we're not talking about milkshakes, obviously. Okay, and then of course we don't want these products to contain other substances such as tobacco, alcohol, caffeine, carbs on the list as well. But where things get strange is that we can't have food and cannabis products processed in the same premises. And yet to me a cannabis muffin is food. So, well, not my normal food, okay, but it is a type of food. And so the rule seems to say, well, yes, this can be done, but then put obstacles in the way of doing it. And this is one of the examples of where I think the bill needs to be tidied up to try and, because there's a very clear intention that these products are to be made available, and yet they've made difficulties. There are also advertising restrictions that I'll get into that get in the way a little bit as well, okay? And whatever, and the other thing is that any cannabis edible has to be approved before it can be sold. So we won't be talking about getting approval for each individual muffin, but we'll get approval to make muffins according to a particular recipe. No vending machines, so we can't have them around the university doling out a bit of cannabis every so often. There are quite tight restrictions on the operation of retail premises. So there are licensing criteria. So there is to be priority given to not-for-profit organisations, particularly those which are willing to give back to the community in some way. Particularly, I suspect, and it's not a rule, but if they were to give back in the way of drug education or something like that, I think that would help them get the nod. It also has to be suitable for the character of the neighbourhood, okay? So we take into account things like local schools and kindergartens and churches and sporting facilities, and keep some distance between them. And then there's another, and it's again a bit of overlap, we look at the amenity and good order of the locality. So one thing that's going on here, I think, if we have posh suburbs, then that might be inconsistent with that particular amenity or locality to have a drug shop in that particular location. But it also says that, okay, we might have areas of town which are so bad that adding one of these things will not detract from the amenity and good order. Doesn't necessarily give a green light, but it is something that's to take into account. So it could lead to a bit of an aggregation in particular areas. No one under 20 is to come onto the premises. There must be a responsible person at each location. So we do contemplate that we might have, the sort of, I'm trying to think, the McCannabises of the world, like McDonald's will have McCannabis, and lots of them all around the country, but they must have a responsible person at each location. And I'm confused again. I don't know if they also have to have a duty manager or whether the person can perform the same roles. It's not clear at all. But the role of this person in particular is cannabis-related harm reduction. And there's fit and proper person tests for both for licensees, for responsible persons, and for duty managers. There's to be no supply to impaired persons. And here we have a definition, someone who is noticeably affected, either in their mental or physical abilities, due to cannabis or due to alcohol. A retail premises is strictly an off license, it doesn't permit on-site consumption, but I think someone can apply for both a consumption license and a retail premises license, because they refer to someone who only has a retail license can't allow consumption. So a bit of an interpretive process makes me think, well, they can also go for a different sort of license at the same time. Certainly there's nothing to restrict that. So then we have the consumption premises. And I think it's the New Zealand Drug Foundation is saying, well, these are places where people come as a bring your own. Okay, I'm not quite sure how commercially that would work. You know, here's a venue, you can come and smoke your own dope, okay? They can supply food and non-alcoholic drinks, but again, so that's why I think these things will only work if they can also be selling the product at the same time. As you'd expect, the licensing regime for this is very similar to that for the retail premises. And as I say, there's nothing that says you can't combine this with the retail premises. So I've got a few additional notes. I better make sure I've not skipped any. No, I'm good. Advertising and marketing is very tightly controlled. Well, it will be. So you can't advertise cannabis at all. So there's no cannabis product advertisements unless authorised. And they need to do this because they've said that any health notice relating to cannabis is treated as being a cannabis product advertisement. Okay? Can't make therapeutic claims about cannabis. Also says you can't mislead people, but that's already the background law, so I haven't gone into that. So what it does mean, even if it's an established genuine therapeutic benefit, that cannot be claimed for the cannabis. The only way you could do it is if it's qualifying as a medicinal cannabis outside this regime. If you go inside the premises, all you're going to be able to see are lists of the products and the prices for those products. So yes, we will be able to have 14 grams of cannabis, X dollars, cannabis muffin, Y dollars, and so on. Okay? There has to be a health warning in the premises and on all packaging. And another weirdness, no product can be visible even within the premises where the public have access, unless it's classified, and we've got no classification yet, but unless it's classified as standard risk product, except as necessary to deliver to a consumer. And edibles are not a standard risk product. So on that reading, they're never to be visible, which is why I say there's a bit of a problem with the advertising rules. Oh, sorry, it's on the next screen. In terms of what's going on outside the premises, the business name, trademarks are permitted, but no reference to the fact that they're selling cannabis, and they can't get around that by using cannabis in their name in some particular way, okay? So I wonder about CannaSouth, whether that's a sufficient identification with cannabis. And then there's the name I've got for my own business I might start, called The Bakery, where not just the cakes are baked, There's no reference to cannabis there. I might get away with it. Yeah, I'm a consumer law. I'm into this sort of thing. Okay? And then, of course, there are many controls on the use of cannabis-related trademarks, on sponsorship, so you can't have the cannabis youth rally around Dunedin or things like that, and on promotional activities, so you can't go to the supermarket, get a free tin of cannabis with your ham. Hadn't realised it was a comedy show, Nicola. Just to finish with a bit of an oversight. So there are statutory purposes set out in Clause 4. Some of them you'll have picked up from what I've already said, to control the supply chain, control the availability, control the use of cannabis. We want to restrict the access of people to it, particularly young people, so we have that complete bar. We want to increase public awareness of health risks, access to support services, and probably the most important thing, access to legal and quality controlled cannabis by adults. Now, there's a lot of future provisioning for quality control. It's not there yet, so that in this respect, this is a work in progress. There's going to have to be quite a lot of work done if it does go ahead. But the overall intent is reducing harms from cannabis use to individuals, families, and their communities. And I think this is my last slide. We have the Cannabis Regulatory Authority, which sits over everything. It will have oversight of the market. It is to promote well-being, reduce harm, reduce cannabis use. That's one of its stated objectives and requirements. It is to develop meaningful relationships with Māori in a way, hopefully, that will help that process. It doesn't quite say, anything more than that at this stage. Quite importantly, it has to have a national plan for achieving the statutory objectives. And specifically, it has to have a harm reduction strategy, it has to be developed. It will control all licenses. It will set controls for things like cannabis potency levels. It can set standards for cultivation and processing, and it might make rules relating to how cannabis is to be packaged and marketed. Okay? It is a couple of things it's to do. It has to do a risk assessment of cannabis products to decide whether things are normal risk or elevated risk. Anything which is an elevated risk is going to require an individual approval by the authority before it can go into the market. So as I said, every type of edible, for example, and there will be other cannabis products. This is the only one the Act has responded to at this stage. There will be other cannabis products, I'm sure, that they will say, no, this is elevated risk. Products have to be tested before they go to the market. Things for not just potency, but the quality of the cannabis as well. Make sure it's as healthy as it can be product. And they'll be setting levies. The idea is that these can be used to fund harm reduction. I think that's my last slide. So I'll set up for Jeannie. Not Jeannie, sorry, Dawn. Jeannie was yesterday. You want this one, eh?
Okay, how am I for audio? Can you hear me right at the back? Yep, good. All right, so I get the exciting third part, which is the safety regulation, which I find exciting, but weirdly not everyone else loves safety regulation as much as I do. So I will go pretty quickly through. We are running a little bit over time, and also I am aware that not everyone loves safety regulation. So what I'm going to do is look at 3 areas. The safety regulation, workers that are currently in the cannabis industry and the impact of legalization on them, and then wider workplace impacts for people not in the cannabis industry. And I'm going to look at the implications of a yes vote or a no vote, and I've also got a sort of maybe it depends section, depending on what the government will end up doing. And this is using Barry's laptop when you're when you're a Mac user. Okay, so the cannabis industry as it stands, there's not a lot of research. As you can rightly imagine, the existing cannabis industry doesn't produce a lot of reports. They don't file a lot of annual financial information, or do they file a lot of PAYE? But from my research on what's available, the industry's worth somewhere between 1.3 and 2.5 billion New Zealand dollars. So we're talking about a fairly substantial industry. The estimates suggest about 74 metric tonnes are moved around the country. So that is 74,000 kilograms is a metric tonne. Not a physicist, sorry. And there's an estimated 557,000 users. So what I'm giving you that data for is not to give you an accurate figure, because we don't know the exact figures, but to give you an estimate of the fact that we've got a really big industry. And it is already criminal. In terms of meeting the equivalent in a legalized market, we're looking at 112 growing licenses, 35 processing licenses, and 207 retail businesses. So again, we're looking at a reasonable sized industry. As with the industry, it's hard to work out the workforce. Most people don't put drug dealer or cannabis grower on their census forms, but there's an estimated 5,000 full-time equivalent positions in the new cannabis industry, and I've seen anywhere between 1,000 and 10,000 current people involved in cannabis presently. So we're talking about a big industry, and we're talking about a product which does do harm. Now, as Andrew said, we are not scientists. I've put up a link there to the Prime Minister's Chief Science Advisor's report, where they evaluate all the science relating to the harm, and I have borrowed/stolen their graph comparing cannabis harm to alcohol and tobacco harm. Because when we're looking at safety regulation, it's useful to have something that we are comparing it to. Okay. The safety regulation that we're introducing, if this does get a yes vote, is a harm reduction approach. So cannabis does have harm in the same way that tobacco and alcohol and a number of other substances cause harm. We don't have the option of perfect safety or perfect elimination. It's really just about reducing the harm to the extent that we can. As Barry mentioned, we have a new agency, the Cannabis Regulatory Authority, who will be primarily in charge of safety regulation. We have a set of new rules, and under those a set of tertiary instruments or lower level regulations on the quality of the product, the potency of the product, and the safety of the product, and I'll go through those in a little bit more detail. We're introducing new requirements for labelling and packaging. There'll be conditions on licence holders in relation to safety. We've got a range of new offences and, of course, a new research and strategy development function as well. So presently, with cannabis being criminal, we don't have that much research on either the substance and its health impacts, the industry, workers in the industry, pricing, etc. And that ability to do research will help with the safety regulation. Okay, the Cannabis Regulatory Agency, as mentioned, produces a national plan, and included in that is a harm reduction strategy, including public health promotion, drug education, monitoring the extent of social harm, and commissioning independent scientific research. Standards and testing. A range of product standards will be introduced across the whole supply chain, so everything from seeds and nurseries through to the actual point of sale. No product will be permitted to be sold unless it's tested, and it's not only being tested for its potency, but also for any contamination, pesticides, heavy metals, etc. So if we think about the current industry, your drug dealer might be testing your weed, but more likely they're probably not. So that in itself is quite a significant improvement in the quality of the product. Your labelling and packaging will include information about the harm, beneficial effects of not smoking or consuming, how you should use the product safely. Your packaging has to be child resistant. As you can imagine, you want one of those kiddie safe tops. You certainly don't want the kids getting in and eating all of your expensive edibles. Limits on quantity of 14 grams. Your packaging has to have a security feature, so you can know that it hasn't been tampered with. It has to have a packaging date and an expiry date. I don't suspect many dealers are putting packaging and expiry dates or safety features on their little plastic bags and rolled up tin foil. Recommended storage, and of course the packaging has to be opaque to prevent sun damage to your product, preventing contamination getting in, and of course moisture getting into the product. So in that sense, it's very much like how we're regulating food. The packaging and labelling of food has very similar requirements there. There has to be security and containment. So if you're running any kind of facility, either growing, production or retail, you have to have security on the premises so that you don't get robbed and you can deal with any intoxicated persons. I imagine that there is plenty of security and containment in current gang-related drug houses, but for different purposes entirely. The current position, by comparison, if you vote no, safety regulation is left to the market. And the market, which I'll go through in a moment, heavy influence from gang and organised crime. So it depends how well you think that market's going to self-regulate. There's no safety regulations that I'm aware of, no product standards, no testing requirements, no packaging and labelling requirements, and as I said, security and containment activities are more about avoiding police detection and rival criminal organisations than they are about consumer safety. Okay, so very brief overview of safety regulation. You're welcome. I could have gone on for an entire hour and a half on safety regulation. I want to look at workers in the cannabis industry because, to my knowledge, there hasn't been any discussion of the fact that we are decriminalising work and the way that we had decriminalised prostitution, and we were interested in how is that going to impact on sex workers. We've had no discussion about what's happening with workers. And part of that is likely to be because it's rather difficult to know who the workers are and how they're being treated. Undoubtedly, at the very top, there are some drug dealers making a goodly amount of money and they're just fine, thank you. Those aren't the ones that I'm interested in. I'm interested in the ones at the bottom who probably, given the choice, would rather do something else or at least have other employment options. So what we know is that the numbers of workers is likely in the thousands, so somewhere between 1,000 and 10,000. Split the difference, say 5,000 workers, and they're employed in a range of roles, obviously growing, trimming, harvest, production, weighing, distribution, delivery, quite a lot of potentially IT roles nowadays, looking at the sophisticated delivery, and probably some in finance, general organisational management. I did a bit of a search on cannabis-related jobs on Seek and also looking at some of the medical cannabis providers to see what kind of job profiles they were looking at. There will be, I think, a shift in the current workforce to the legalised workforce, so more science jobs, a lot of jobs for analytical chemists, biochemists, agronomists, those of you in that field, it's looking pretty good there, but also reasonable for packaging, warehousing, distribution jobs. What we do know is that there are some small self-employed operators. There are also some very large, very sophisticated operators working with networks of workers. We know that gangs have a significant market share. We don't know exactly what that market share is. And we also know that there are connections to both overseas criminal organisations and other criminal activities. So workers are working in those sorts of organisations. A proportion of them will be very vulnerable people. Yeah. So they will have been brought into cannabis-related work through some fairly dubious recruitment practices. So if you can imagine, most drug dealing isn't advertised on Seek at present. So the way that people are brought into that industry may well be they are users, they could have debts and they're borrowing from these organisations. That seems to be a pattern where people are brought in. Once they are in to the job, it's quite hard to get out, either because of the way the organisations work or simply that you're then tied into that organisation. You've got no proof of income, you've got no contract, you may well be borrowing from the organisation as well. Those people are at a particular risk of violence and victimisation, little ability to seek help if there are problems arising. So as you can imagine, if you are a cannabis grower working for a large gang, there's no HR department, you can't just knock on the door and say, hey, we haven't got safety boots, and I've been mauled by a dangerous dog at a tinny house, and we're going on strike. So there's no employment rights there. If you get robbed or you're a victim of assault, your ability to access legal enforcement or support is limited. No health and safety regulations. It is likely to be a dangerous job, made even more dangerous because it's criminal. And of course, you've got the risk of prosecution and imprisonment, which makes it harder for you to find work somewhere else. So if we legalise cannabis, we're legalising cannabis production work, which should see health and safety improvements, minimum working conditions, associated rights like ACC and KiwiSaver. Now, I'm just going to assume that most drugs don't have KiwiSaver schemes, but again, I don't have evidence around that. There could be some very good drug operators in the market. My suspicion is probably the majority don't. Having an employment contract and proof of income means that you can do things like get legitimate bank accounts. It means that you can rent from the private rental market because you're able to access those tenancies rather than potentially through organised criminal networks. You're able to put your work history on a CV, and you're not exposed to the risks of criminal activity in the same way. You're not economically tied to those organisations. Okay, I'm doing great guns. I will make sure we have plenty of time for questioning. As I said, the implications for legalisation is hopefully going to be improved conditions for those at the bottom. It might impact on the profits of those at the top, but I'm less concerned about drug dealers at the top than vulnerable workers at the bottom. Okay, workplace use. Does the legalisation of cannabis mean that we're all going to turn up to work stoned? Probably not. For the same reason that most of us don't turn up to work drunk. The legal status of alcohol has very little to do with most people's decision not to turn up to work drunk, and has more to do with them not wanting their bosses to think that they're irresponsible or whatever else. So I can't see a huge increase in that. In terms of some new workplaces where cannabis consumption will be allowed, although Barry's mentioned there might not be quite so many of those, there will be specific rules for that. The Health and Safety at Work Act will of course also apply, and the Health and Safety at Work Act applies to obviously the workers but also others in the premises. Most other workplaces, so for those of us who work at universities or pretty much anywhere else, they won't be licensed to allow cannabis consumption on site. So chances are there will not be any legal consumption on site for the majority of workplaces. If there is consumption on site, employers of course can enforce their own site work rules in the way that they can with any other practice that they don't want happening. And the Smoke-Free Environments Act, I suspect, will be amended to make clear that smoking in workplaces or public places includes smoking weed. It doesn't currently look like it's drafted that way, but I think it will end up being amended to do that. What about if you are enjoying cannabis in your own private time? Can you be dismissed for your outside of work cannabis use? So inside work you can be dismissed if your boss is like, hey, why are you smoking weed on the job? That's fine, has always been the case. Activity outside of work. At the moment, the fact that cannabis use is criminal makes the employment law much more complicated than it needs to be. Because the criminal status of the activity shifts the way that it's responded to. And I'll talk about what legalisation might do in just a moment. Effectively, you can be fired at the moment if your outside of work criminal activity is sufficiently connected to your job and is fair and reasonable in all the circumstances. So at the moment, the law says it depends, and maybe. You might be able to be dismissed from your job. Making that more complicated are privacy and discrimination issues. And the case law at the moment, we've got two fairly contradictory sets of case law, making it more difficult for both employers who are trying to manage staff, but also for employees to be able to defend disciplinary matters. In my view, either way, whatever the determination is in the referenda, the law needs to be reformed. Legalisation is likely to make it easier, and the reason is that WorkSafe and the Privacy Commission haven't gone into those areas, partly because it's criminal. So they don't want to be seen to be endorsing criminal activity, even though they could potentially do that. If it's legalised, the activity is no longer criminal, And for a person to be dismissed from their employment, their cannabis would have to, use would have to impact on their ability to perform the job. So it would either have to be against the rules in terms of workplace use, they've turned up to work impaired and they can't perform their job performance has been affected in some way, or there's a health and safety issue. So legalisation means that you can only be dismissed if your cannabis use is having an impact on your actual ability to perform the job. Drug testing is another area of employment law which is a bit unsatisfactory. The current law comes from cases which started in 1996 with the Air New Zealand case and said you can do drug testing in safety sensitive areas. So only in high risk areas are you allowed to drug test employees. But it also has to be fair and reasonable in all the circumstances, and that's how you introduce a drug testing policy, how you carry it out, how you communicate, and then of course any decisions that you make as a result of a positive drug test. As I mentioned, there's no guidance from WorkSafe about the health and safety implications. There's no guidance from the Privacy Commission about individual privacy rights, and the area needs some reform. If legalised, WorkSafe could more easily issue guidelines, and particularly addressing the issue of drug-related impairment. How do you deal with an impaired worker? When drug use creates health and safety risks, how you as an employer should respond to those risks, and when drug testing is appropriate and helpful. Now I've got a note there about drug testing. If you introduce a workplace drug testing regime and drugs are not a primary hazard in your workplace, you run the risk of increasing your injury and illness rates. So it's not just that there's a no effect of introducing a drug testing regime, it's a negative effect. So what happened when they brought in the Health and Safety at Work Act a couple of years ago is some employers thought a nice, cheap, easy way to show that we care about health and safety is introducing a drug testing regime. What happens is if you introduce a drug testing regime and there isn't a drug problem, the drug testing ends up chilling people's ability to communicate, or willingness and goodwill to communicate with you about health and safety issues. So looking internationally, a badly introduced drug testing regime is worse for health and safety than not introducing a drug testing regime, which is why I'd really like to see, if it's legalised, WorkSafe bring in some proper guidelines for people about when it's helpful and actually when it's harmful. The final point on health and safety is around occupational violence. So occupational violence is a category of health and safety hazard in the workplace where people get assaulted by somebody else in the workplace, whether that's patients or customers or inmates. We see this a lot in hospitality. People working in bars get assaulted by drunk patrons. You see it a lot in the health sector. Emergency department workers and ambulance workers get assaulted by patients. Looking at the international evidence, there's not a lot to suggest that legalising cannabis will increase the occupational violence risk, and the reason for that is by a huge margin, the primary culprit for occupational violence is alcohol. So as we're not changing the legal status of alcohol, it looks like it will remain number one contender on occupational violence. Okay, so a very brief summary of workplace impacts. Most workplaces outside the cannabis industry probably won't see any real change as a result of legalisation. Most workers aren't using cannabis now, probably won't use cannabis in the future. Most workplaces don't have drug use as a primary hazard. It's more likely to be things like fatigue or stress or working hours or unmaintained machinery. So there's no real need to introduce mandatory drug testing. Legalisation may help to clarify the law in some places around dismissal, disciplinary action. We will need future reform. And we will need future reform around impairment and drug testing. We will see a significant change for workers in a legalised cannabis industry from a criminal industry. And it's worth noting that a conviction under the Misuse of Drugs Act presently will not prevent somebody from either obtaining a licence or obtaining employment in the legalised industry. So there is a potential for some workers to shift from a criminal industry into a legalised industry and enjoy what I presume will be the benefits of increased safety, KiwiSaver and all of those sorts of things as well. Okay, I've done a rapid speed through. You're very welcome. We have 15 minutes now for questions.
Which one? This one. Because this one runs better. Okay. If anyone's going to Helen Clark, if you'd like to want to leave now, go away. Yeah, I'm not saying go away. So now's a good time for you to enjoy the talk with her.
Right. So my name's Rex Arter. I'm a colleague of this trio here, and I'm just chairing the thing because Barry can't. He's one of the panel. So do we have any questions of our three panellists? What? Yep. All right. Someone up the back there.
You're next.
I was just wondering, regarding the regulations on individuals, how will those regulations actually be enforced? So, like, for example, the limit on buying 14 grams a day, what's to stop someone from just going to multiple outlets in that same day?
Nothing. I mean, that's the reality. It's going to be very, very hard to police some of these things, just as it is now, because yes, there is a record-keeping requirement, and so you might get detected, a long time after the event that, oh yeah, Barry's been and bought from 3 different places on the one day, and I guess at that point there might be some enforcement.
Have another question? There we go.
Yeah, thanks very much. Great presentations. Just going back to the current Act, sections 7.5 and 7.6. Is there a definition of the public benefit that this whole business of we're not going to prosecute you for?
Andrew?
No, there's no further definition in the statute itself as to what that means. What we don't have, and what I think if this stuff's going to really bite, is for someone to challenge a prosecution. So what you really need is someone who is prosecuted and then challenges the decision to prosecute, alleging you shouldn't have prosecuted me here because it's not in the public benefit, you should have done this instead. And until someone brings that sort of claim before the court, and the court can then give some judicial guidance as to what all the stuff means, it's really left in the hands of the police to try to work out what they think it means.
Can that happen in a case?
Yeah, so someone could. So this is going back to the provision that was put into the Misuse of Drugs Act that said there is a discretion and you should exercise that discretion and only prosecute if it's in the public benefit, and in deciding if it's in the public benefit you should take into account health alternatives instead. Now, because that's been put into statute, it's statutorily binding on the prosecutorial authorities when they're deciding what to do. So you could go to court and allege that the prosecution has failed to follow the statutory guidance in Section 7.5, Section 7.6. They failed to do as that requires, and therefore the prosecution should never have been brought. The flip to that is it would cost a hell of a lot of money, because you'd have to appeal, essentially, seek a judicial review, go to the High Court. It would be very expensive. And that's the problem with all sorts of things. You can put stuff into the law, but in order to actually enforce it, you've got to get someone who's actually prepared to get a lawyer and challenge it in the court, and no one's done that yet.
So we have another question? No more questions. Go on.
Thank you, sir.
So I'm just interested in the ongoing illicit supply, if this is passed, which is probably likely to continue. Does the current regime still apply in that case? You know, for example, kids getting it off their mates in the schoolyard and things like that. No, they don't know where it's come from. Will that still apply in this case?
No, this bill would replace the current legal regulation, the current prohibitionist regime under the Misuse of Drugs Act. So, for instance, a 18-year-old giving another 18-year-old some drugs would be what Barry was talking about as being a low-level, perhaps $200 fine or an infringement notice. So there would still be some consequences, but it wouldn't be the potential jail term and so on under the current Misuse of Drugs Act. Gangs which keep on trying to sell drugs, well, they won't be licensed to do so. And so under this new regime, they'll face the criminal provisions under this new regime and so on. But all the Misuse of Drugs Act prohibitions that exist will disappear, and new offence provisions will come in under this new Cannabis Control Bill, some of which are still pretty severe. Selling drugs without a licence still carries a fairly heavy tariff. But others of which are going to be much, much more minor. So a couple of 18-year-olds giving each other marijuana, if anything, they'll pay a couple of $100 and be told, don't do that anymore.
I mean, the idea is to carve out cannabis for a separate area of control. Yep.
Thank you. Just following on from that, it just strikes me: would it give the criminal gangs an incentive to target children because adults can get it legally? I mean, do you know what I mean? I'm just wondering whether it kind of introduces any perverse incentives.
Well, as I said, in terms of supply, the supply to a minor still carries quite heavy imprisonment. I think it's a bit less than under the current legislation, but it's still quite a hefty response to that sort of behaviour.
But I mean, to take your point, I guess we just don't know. I mean, that is a possibility. Of course, there's still a market at the moment. So, someone's giving them this stuff and someone's, passing it on. And, I think most people who've got any connection with teenagers know that they're able to find it. The one thing I guess we can say is, insofar as we can make any sort of predictions, if we look internationally at youth usage in the places that have legalised, and you'd expect, same argument would go, well, the black market surely would go there. Youth usage is still falling in those places. I mean, it's falling across the board. It just hasn't reversed in those places that have legalised supply.
Perhaps I might add a little postscript, if I'm a member of the panel. The New Zealand Medical Journal had a good article about article 2 or 3 months ago. It pointed out, amongst other things, that when you legalise cannabis or marijuana, in those jurisdictions that have it, does not eliminate or see the end of a black market in cannabis, catering for those users or parts of the market that are not currently legal. So, for example, in concentrations of marijuana beyond the legal area. So the short answer is the black market does not totally disappear even once you legalise cannabis.
Thank you. Just picking up on the bill, and I guess it's a question just to all of you really. To what extent do you see that there's, because my understanding is there's going to be submissions called for, public submissions and so on, and presumably submissions from experts as well. A couple of questions. First of all, do you folks, as working within law in a tertiary context, are you contemplating looking at the issues that you've identified tonight, which have been very interesting, and making a submission on those? Secondly, I mean, some of them are quite unworkable, aren't they? It's quite weird, like this business of potency. You've got a limit, I think, of 15% THC. But I mean, people are allowed to import seeds. I mean, what are they going to do? They're going to grow some of the seeds and test them. There's some real problems with it.
I just to answer for myself first in terms of the submission question. Now that I've invested a fair amount of time in getting my head around the sort of wrinkles of the Act, I mean, I'm not an expert on the sort of drug side of things, but I have seen quite a few just to make the act better than it is in terms of fitting together better. So I've got quite a few ideas in that area, and so I probably will be, if there is submissions called for, responding to that to try and get a more workable piece of legislation.
Yeah, all legislation ends up getting changed at some point in its passage through Parliament. I mean, that's, the initial draft goes out, goes into the House, goes to Select Committee. After hearing about it, the Select Committee makes changes to it and so on and so on. What's slightly different about this bill, I guess, is that this bill is going to enter into Parliament with kind of the endorsement of the New Zealand people. This is what the New Zealand people want to see become law. And I think that might put real sort of constraints on how far the legislation in its sort of fundamental form can be changed. Because, if the New Zealand people have said they want this bill, and then the government was to go, well, actually, now we think we want to change it considerably, it's kind of, well, what was the point of the referendum? You know what I mean? But certainly in its details and all the kind of, well, it doesn't really look like that's going to work very well, and surely we can tweak that. I mean, that's what select committees are for. That's the whole point of having a legislative process. Will I put in a submission? I'll probably say something. I say something on lots of things.
I'll probably say something about the impairment, the workplace impacts, the safety impacts, but a lot of that will come after the legislation passes through itself. So there's a lot of provision for regulation, sort of tertiary instruments, guidelines underneath it, which is probably where I'm more interested in terms of getting those work-safe guidelines, getting the drug testing guidelines, things like that, which will come underneath the legislation.
I just had a little comment that I'm being an antitrust lawyer, competition lawyer, I'd be concerned about the concentration and the monopoly effects of this market, and also the danger of foreign investment by other, perhaps even the good old CCP who have vertically integrated into New Zealand dairy industry. So I could see them seizing the chance to do the same in this industry as well.
Yeah, 20%.
Oh, that's good to know.
Yeah.
Okay, well.
They've already thought ahead of you there, Rex.
Oh, it's only 128 pages long, the Act, so I read
it. You mentioned at one point, I think, Barry, that Canada has just moved to the point where it's just over 50% is now in the legal market as against illicit. And so how long has cannabis been legalised in Canada? And in any other countries, have you got any sense of how long it takes to move, maybe not completely, but significantly towards legalised use?
I have to confess that I've been sort of scrambling to get on top of our own proposed legislation without doing much international research. But I do know that Canada has had cannabis legal for more than a decade. Do you know, Andrew? About 3 years. Oh, is that all? Okay, thank you. I thought when I was in Canada there were cannabis shops when I was there. Okay.
So if the majority were to vote yes for the cannabis referendum and then the bill was to go through its legislative process through Parliament, how long could we expect it would be until the Act would be in force? And my second question is that you said the Labour and Green government said that they would put the bill through the process, but what happens if after October 17th that we have a national-led government? Would we expect a different outcome from that?
On the timing, well, it would depend what sort of priority it was for the incoming government. Let's assume it's a Labour-Green government. What level of priority would be given to this piece of legislation, how quickly it's put before the House? It would go through then to Select Committee. Select Committee stage takes 6 months. After the Select Committee process, there's then another couple of steps which could take 2 or 3 months, but it's entirely feasible, I think you could see by the end of next year this could be law, but can't say that for certain.
There would be a settling-in period after that though, wouldn't there?
Well, yeah, and then there would be a requirement to sort of create all the regulations and the extra sort of stuff to do it, so it may not come into force for a little while after that. As I said, the National Party position at the moment is that if there's a yes vote, they will pass it through what's called the first reading, the first stage of Parliament, and send it to Select Committee, and then allow Select Committee hearings so the public can say what they think about the bill. At the end of that, they will then decide whether to proceed with it and go any further. If a majority of the public vote yes, that will create some moral political pressure to act, but it's only moral political pressure. Nothing more can be done than that.
I think we'll have one last question. We have hit 7 o'clock, but I see a hand at the back.
Hi, I was just curious, because the thing is so long and there's so much about harm reduction and that sort of thing, if there was anything mentioned about how education in schools might change and how they frame cannabis?
There is a public education role, so that could go, there's nothing specific, but educating the public is certainly one of the requirements that the Cannabis Regulatory Authority is supposed to see to. But, it will be up to the authority to make the detail of that.
You're probably closer to this than we are. So, going through schooling, what kind of health education was there around alcohol?
None.
Doesn't really, right? Essentially the New Zealand curriculum would need to be changed to include this sort of stuff to be talked about. I suspect maybe if we have 2 legal drugs widely available in society, that might create more of an incentive to, actually talk about the stuff in school. But you would have to change the curriculum to actually allow it to happen.
Yeah. One would hope that as this does pass through, they must look at sort of contemporary changes to society. So, school could look at it in that kind of context. But I think it's come to an end. So once again, I thank everyone for coming. We couldn't have done this without an audience. Anyone here last night would have heard that already. And obviously, I have to thank my 2 colleagues here for coming along, and I join you to thank me. Thank them, sorry.